thanks very much for the opportunity to speak today. Can I also begin by acknowledging the traditional owners of the land and paying respects to elders past and present. Can I acknowledge the President of the Australian Human Rights Commission in her absence, Cathy Branson, and also Dimitrina Petrova. It's lovely to meet you. And there are a couple of colleagues from other states who I'd just like to acknowledge here as well. What I wanted to do was, I guess, try to breathe a bit of life into the Equal Opportunity Act in Victoria, and my take-home word for the year, I think, is going to be, is it negative-tropic? Is that right? Is that what you said? Because I think we've been through a gross negative-tropic process in Victoria, one way or the other. We've had more changes than an actress's change of wardrobe, I think. But at the heart of all of those changes, I think what we have is actually a really modern Equal Opportunity Act. And it's interesting when I listened to the previous presentation, just how many boxes we tick in terms of the overall architecture and structure of the Act. So what I want to do is just remind you in a kind of very active sense about the objectives of our Equal Opportunity Act in Victoria, and these remain unchanged, notwithstanding some of the tinkering that's been made in the last 12 months. And I guess the overriding issue is that the Act really has picked up the notion of the positive duty that exists in our State Human Rights Act, and so there is an onus on duty holders to be proactive and to act through a positive duty to reduce discrimination to the greatest extent possible. And this really means that there's a significant emphasis at looking at, I guess, the prevention of discrimination and being proactive. And we actually kind of use the words when we do our training around prevention, about being proactive, about actually trying to look at not only how you reduce discrimination, but how you get better outcomes, whether it's in employment or accommodation or sport or whatever the case may be. The second really unique feature, I think, of our legislation is it actually talks about systemic discrimination. It doesn't define it per se, other than our simplified, clearer definitions of discrimination, but it talks about the identification and elimination of systemic causes of discrimination, sexual harassment and victimisation. And I think the third really important feature of our legislation is it talks about promoting and facilitating progressive realisation of equality as far as is reasonably practical. So, you know, there are some qualifications around it, but it's quite ambitious in its objectives to that extent. And for the Commission, and in terms of us administering our responsibilities, our functions under the Act, this really gives us quite a rich palette of opportunity in terms of actually what we can do to facilitate the realisation of equality in Victoria. The other interesting things about the legislation is it actually, in its objectives, acknowledges that discrimination can cause social and economic disadvantage, so it starts to make that link around socio-economic considerations. It acknowledges that access to opportunities is not equitably distributed throughout society. It actually talks very specifically about the equal application of a rule to different groups can have unequal results or unequal outcomes. And it actually talks about the achievement of substantive equality and indicates that that may require reasonable adjustments and a reasonable accommodation in the taking of special measures. So I think that as the Act is set up, it is quite ambitious and it's quite progressive in terms of what we're trying to achieve in this state. Now, there are other things that have been changed. So we have had a simplification of definitions. So if you think about Dimitri's comments about the comparator, our definitions of discrimination, both direct and indirect, have been simplified substantively. We've been, as a Commission, we've really been asked to try to shift the emphasis, I guess, on a complaints-based individual approach to trying to address discrimination, to being much more proactive and preventative and having a focus on systemic discrimination. And certainly in terms of our functions as a regulator, there is a significant emphasis on actually facilitating compliance. So just demonstrating what compliance looks like. What does it actually look like to identify systemic discrimination? What does it look like to actually try to achieve substantive equality? So all of that framework is really critical. The one comment I would make is that if a regulator is going to be facilitative, actually on helping people understand, duty holders understand how they can actually respond to the positive duty under the legislation, as well as engaging people to understand what their rights of protection are under the legislation. So in terms of how the positive duty operates, it requires employers and service providers to take reasonable and proportionate steps to eliminate discrimination, sexual harassment and victimisation as far as is possible. And the significant recognition in this change of emphasis is that what we all know, that whilst it's important that individuals do have opportunities for individual remedy, that they can actually bring complaints of discrimination where they occur, we know that the complaints that we receive across the country are only the tip of the iceberg, and there is a significant onus that's placed on an individual when they're trying to actually demonstrate that discrimination has occurred, and it may impact on more than them. And I think the examples that Dimitri gave of the recognition of the difference through disability discrimination law is really critical in that respect. The notion of reasonable and proportionate measures in our state legislation is quite specific. So there's an acknowledgement that duty holders are different sorts of entities, and the legislation specifically acknowledges that when consideration of reasonable and proportionate steps is going to be taken into account, the size of the organisation or operations, the nature of the organisation, its resources, and the practicality and costs associated with reasonable and proportionate measures will be taken into account. The other improvement, I guess, in the legislation is in the notion of reasonable adjustments, and I think that the way that the reasonable adjustments section has been brought into the legislation makes it much clearer, this notion that it's actually there to achieve equality and to facilitate the realisation of equality. And there are many examples of how reasonable adjustments can be made. We have some modest additions in terms of, I guess, areas that are covered by the Act. Volunteers are now covered under the Act only in relation to sexual harassment. So again, I think the previous presentation where we talked about equality and human rights law reform process has been very political. I think that's been our experience here, you know, to actually get a group in the community who are probably a growing group. Do you want me to stop? I'll finish my sentence. In terms of volunteers, that was quite insightful, and it really was a kind of last-minute negotiation to include volunteers for protection from sexual harassment. Just remember everything I've said. That's all right, I'm happy to do it.
Kate and Richard, can you hear us in there? Can you hear us? Hello? Hello, Kate and Richard. Hello? Hello, can you hear us from Australia here? Hello? Hello, can you hear us? Can you hear us? Hello, hello, hello. Hello?
If you can hear us in the front row, can you wave or something? Because we can't hear us.
If you can hear us, Richard, please feel free to start your presentation.